Hello and welcome back to the Florida Rights Institute informational video series. We're going to be talking about Florida declaratory judgments with injunctive relief and give an example of how a declaratory judgment is filed seeking injunctive relief. The following presentation is meant for informational purposes only and is not intended as legal advice. Seek a licensed attorney if you need legal assistance. Floridians can seek a declaratory judgment from circuit and county courts. Florida Statutes Chapter 86 Declaratory Judgments. In Section 86.011, the jurisdiction of the trial court is noted. The circuit and county courts have jurisdiction within their respective jurisdictional amounts to declare rights, status, and other equitable legal relations whether or not further relief is or could be claimed. No action or procedure is open to objection on the ground that a declaratory judgment is demanded. The court's declaration may be either affirmative or negative in form and effect, and such a declaration has the force and effect of a final judgment. The court may render declaratory judgments on the existence or non-existence of any immunity, power, privilege, or right, or of any fact upon which the existence or non-existence of such immunity, power, privilege, or right does or may depend, whether such immunity, power, privilege, or right now exists or will arise in the future. Any person seeking a declaratory judgment may also demand additional, alternative, coercive, subsequent, or supplemental relief in the same action. Who can file? Florida Statute 86.021, power to construe, says who. Any person claiming to be interested or who may be in doubt about his or her rights under a deed, will, contract, or other article, memorandum, or instrument in writing, or whose rights, status, or other equitable or legal relations are affected by a statute or any regulation made under statutory authority or by municipal ordinance, contract, deed, will, franchise, or other article, memorandum, or instrument in writing, may have determined any question of construction or validity arising under such statute, regulation, municipal ordinance, contract, deed, will, franchise, or other article, memorandum, or instrument in writing, or any part thereof, and obtain a declaration of rights, status, or other equitable or legal relations thereunder. Does the act have to have already happened? No. See 86.051. Enumeration not exclusive. The enumeration in Section 86.021, 86.031, and 86.041 does not limit or restrict the exercise of the general powers conferred in Section 86.011 in any action where declaratory relief is sought. Any declaratory judgment rendered pursuant to this chapter may be rendered by way of anticipation with respect to any act not yet done, or any event which has not yet happened, and in such case the judgment shall have the same binding effect with respect to that future act or event, and the rights or liability to arise therefrom, as if that act or event had already been done, or had already happened before the judgment was rendered. Let's look at an example. Power versus Leon County over the mask orders. The background to this is that Leon County passed an emergency ordinance requiring residents to wear face masks in various circumstances. The plaintiff was a business owner who claimed a negative impact from the mask mandates. The attorneys filing the injunctive relief and declaratory judgment was Florida House Representative Anthony Sabatini and Richard E. Coates of Coates Law Firm. In their filing, the first thing they did was claim jurisdiction and venue. They said that this is a lawsuit for injunctive relief over which the court has jurisdiction. They noted that this is a lawsuit for declaratory judgment over which the court has jurisdiction under Florida Statute Section 86, which we just covered before. And they said the venue is proper in Leon County, Florida, under Florida Statute Section 47.011 because it's where the cause of action accrued and it relates to certain orders issued by Leon County, and because all or part of the claim for relief at issue is in Leon County. So for somebody else filing, of course, you want to make sure that the lawsuit is something that relates to a party that was harmed by the people you are seeking relief against, and that the court has proper jurisdiction. So then they went to naming parties. In this case, Power is a Florida resident and resident of Leon County, and he was a business owner who was negatively impacted as claimed by the attorneys and himself. And then Leon County is the proper defendant because Leon County created the emergency ordinance, which is being challenged. After they name the parties, they go through the fact statement, which goes into the history a bit here of what took place, especially as to Florida Governor's DeSantis executive order, and then eventually what led up to the Leon County emergency ordinance. We're not going to go through all the facts, but as you can see here, and of course you can open up the entire motion yourself, you can kind of get a sense of how they developed the facts here and how that may relate to your own specific situation if you're thinking about seeking attorney for what it is that you need relief for. In the fact statement, of course, it is important to put in there what specifically the instrument is or what the document says, what the order says that is at play here, which is a claim, in this case, for rights deprivation. The fact statement, of course, does include the specific ordinance and the language of what is being said in the ordinance that would affect the plaintiff. I haven't included all of the information here that they have in the ordinance. This is more just for informational purposes only, so you have a sense of what's going on. And of course, in filing these, it's important to make sure that the party is claiming a harm. You want to have a harm that is specifically personally tailored to the plaintiff. And of course, they did mention that here, that plaintiff is a business owner who is personally and negatively affected by the mandate to wear a mask contained within Leon County Emergency Ordinance 20-15. In addition to the background facts and stating the specific document or order that is causing the harm, in addition to the background facts, facts countering what it is that is supposedly causing the harm may be appropriate, especially here where they're saying that the mask mandate is inappropriate for various reasons. They brought in some facts saying how the ordinance doesn't really make sense based on other information. So again, someone else's situation might have different facts as it relates to their personal situation, but this kind of gives a background to how you may potentially bring in facts that counter the facts or the statements or the order from a separate party. After the facts is a discussion of the law, and in this case, the first thing they discussed here was talking about the privacy clause of Article 1, Section 23 of the Florida Constitution. The attorneys go through a couple other legal arguments in terms of suggesting ways that the ordinance and the local order may be violative of Florida's constitutional provisions. I'm not going to go into the specificity of all those different things because each different order may, of course, have different parts of the Constitution or something else like a statute that it is violating. But in this case, again, having a law section that goes over what laws are being infringed upon or the Constitution, what parts are being violated is critical. Next, the statement explaining why the plaintiff should be granted a preliminary injunction is important because you have to lay out the elements of what are required typically to have a preliminary injunction granted. And in this case, they note down that some of those key facts that are required are a substantial likelihood of success on the merits, a lack of an adequate remedy at law, the likelihood of irreparable harm absent the entry of an injunction, and that injunctive relief will serve the public interest. So again, these elements are typically pretty critical to suggesting why an injunction should be accepted by the court. After stating what is needed for the injunction, having rationale for why the plaintiff should succeed on each of those elements is important. So again, in this case, they're going through each one of those elements I just mentioned. They're starting here saying the plaintiff has a very high likelihood of success in the merits because they're suggesting that the emergency order is presumptively invalid. They then go in to say that the plaintiff lacks an adequate remedy at law because there is no other way that there can be a remedy where the injury will be avoided or cured otherwise by monetary damages. So again, they're suggesting here that the shutdown orders, the mask mandates, cannot be otherwise repaired an injury through another manner. The attorneys here are again noting that without an injunction, there will be irreparable harm, especially as relates to a possible arrest. So again, they're emphasizing it's very serious and that the harm of arrest cannot otherwise be remedied. Finally, they talk about the public interest and they say that a temporary injunction of the emergency order will serve the public interest because the other citizens of Leon County can be burdened by the overreach of the government and that it affects them as well in terms of their business and their lives. So again, they're just making a statement about how the general public interest here would be served. After providing rationale for the injunction, the attorneys go on to talk about the counts of what it is they're seeking exactly. And again, saying that they're realleging and incorporating the paragraphs passed, talking about the facts, and saying they seek an injunctive relief. Then again, they are seeking declaratory judgment. They're realleging, incorporating the past paragraphs, talking about the facts, and seeking a declaratory judgment, declaring the emergency ordinance unconstitutional. And at the end, the prayer for relief is specifically what they wish the court to do. They specifically are articulating that they want a declaration that Emergency Ordinance 20-15 violates Article 1, Sections 2, 3, 9, 23 of the Florida Constitution. And they also specifically want a temporary injunction to be ordered enjoining Leon County from enforcing Emergency Ordinance 20-15. And lastly, an important catch-all, they say, and any other further relief as this court deems just and proper. That's an especially important clause because if the court finds that the orders were especially egregious, they may add in other types of measures to counter it or to add more relief. And so you don't want to limit the court from providing even more relief than what you've asked for. At the end of the motion, there is a verification statements where the plaintiff is declaring under penalty of perjury that everything is true and correct as they filed. And of course, the attorneys here, Sabatini and Coates, have signed off at the bottom. So, in summary, to properly submit a declaratory judgment and injunction, you need a party who can show that they have been or will be harmed as relates to any immunity, power, privilege, or right, proper jurisdiction and venue for filing as relates to the party for the actual or threatened harm, a statement of facts, an allegation that the plaintiff is or will be affected, facts countering the perceived harm, a statement why the plaintiff will meet the standards for injunction including substantial likelihood of success in the merits, lack of adequate remedy at law, the likelihood of irreparable harm absent the entry of an injunction, and that the injunctive relief will serve the public interest. Rationale for each injunction element, account for each of the remedies sought from the court, prayer for relief specifying what action is desired from the court, and verification that the statements are true. Thank you so much for watching this Florida Rights Institute educational video. For more informational and educational videos, subscribe here and visit www.floridarights.org.